I am Bill Rochelle, the columnist and editor-at-large for American Bankruptcy Institute. In my column today on the ABI website, I'm writing about a very important bankruptcy opinion. But guess what? It's not an opinion from the U.S. Supreme Court. It's not from a federal court of appeals, and it's not even from a bankruptcy court. In fact, it is from the Delaware Supreme Court. So, you naturally ask, why is it that we care about anything in bankruptcy written by the Delaware Supreme Court? Well, the answer is this. Most of the large corporations that end up in Chapter 11 reorganization or bankruptcy in the U.S. are incorporated in Delaware. And so, therefore, pre-bankruptcy, Delaware corporate law very much governs what a Delaware corporation can and cannot do. And here is the issue. There has been a long-standing controversy over whether or not there is a so-called insolvency exception regarding shareholder votes. Typically, if a corporation is going to sell or transfer all or substantially all of its assets, Delaware corporate law requires that there be shareholder approval. Well, the controversy was this. Is there an exception for insolvent companies? In other words, can an insolvent company without shareholder approval, or perhaps even over shareholder objection, go ahead and transfer all of the assets in a workout, presumably transferring the assets to secured creditors to get rid of a possible bankruptcy? Well, the Delaware Supreme Court, in a unanimous decision on June 15, said no, there is no insolvency exception. If a Delaware corporation wants to transfer all or substantially all of its assets without shareholder approval, you simply can't do it. Well, that has several implications for companies that are insolvent. First off, sounds to me like you cannot have an assignment for the benefit of creditors for a Delaware corporation without shareholder approval. Also, of course, I think it's even more clear that a company in financial trouble cannot simply turn over its assets to its creditors or lenders without shareholder approval. And I suppose I have a little bit of a question about whether or not a Delaware corporation can sign up a prepackaged bankruptcy before bankruptcy without shareholder approval. But I suspect because it's later ratified by the bankruptcy court, it's probably permissible. In any event, this is a very important decision. You can read about it in my column on the ABI website, and by a couple of clicks, you can read the opinion in full text. And by the way, I think anybody who deals with large corporations in Chapter 11 needs to read the opinion in full text. It's 54 pages long. It's going to take you a couple hours or more to read, but it'll be good reading. I am Bill Rochelle, as I said, and I will return same time next week with something interesting and important from the world of bankruptcy. Until then, be well, stay safe, and good day.